All right, so what are some of the things that we do when we get an assault case, right? What are you actually paying for? You're paying for a service. You're paying for us to obviously use our brain and obviously our experience to try to get you the best possible result. So one of the first things that you need to understand is that the government has the burden of proving that you're guilty. We don't have the burden of doing anything. We do a ton of work, and I'll get to that in a second, but we don't have a burden to prove anything. So number one thing we gotta do is we gotta start collecting their evidence. We gotta start picking it apart. We gotta see what things that we can use within their evidence to do our own investigation, because a lot of times law enforcement doesn't do a proper or full investigation, possibly because they were incompetent or because they didn't want to go outside their own narrative, what they believe in terms of their tunnel vision. So we're trying to pick apart their evidence at first. That's how I start, at least. Also, initially, if we talk to you during the first consultation, we hear that there are other witnesses who are involved. We're going to want to try to get all the information for all of these other witnesses. We're going to go out on the scene. We're going to go talk to business owners, homeowners to try to collect camera footage, things of that nature. We're going to possibly work with experts. We could use human factors experts. There could be DNA issues, could be fingerprint issues if there's a third-party defense type of issue in a case. We're going to work with experts. We're going to review literature associated with these things. Even digital forensics experts, we might need people to start picking apart videos, things of that nature. So we'll work with experts if need be. And then obviously, once we start, I always tell clients when they come in, we look at a case from a funnel perspective. It starts real broad, where we're going through the state's evidence, then we start pulling our own evidence through our own investigation, using our investigators and our experts, and we start narrowing down the issues as to what we can use to try to present the best defense for you at trial. In addition to using the experts, literature, things like that, we're going to start interviewing witnesses. Once we have the government's information, we're going to want to see potentially what the witnesses previously said, and maybe what investigators failed to ask, and we're going to follow up once we have those interviews. We'll be following up doing our own interviews to ask questions maybe that weren't asked, or there could be new topics or different areas that hadn't previously been thought of or discussed. So those are some things that we're going to do to try to build a defense before we get to trial. When we get these cases, the first thing that we're doing is looking at, can we win at trial? What can we do to start presenting a defense at trial to get you a not guilty? Because just because you may have actually hit someone doesn't mean that you're guilty of doing it. You could be legally justified, right? There could be reasons as to how you got in that position. It goes to your mental state. That's one component of the elements of the offense, and also obviously the contact itself, what type of contact or feigned contact, attempted contact went into the offense. So we're going to be looking through everything. We're going to be using all our experts, our investigators, doing our own investigation, going out to the scene. We get real down and dirty with the stuff initially, as soon as we get the case and throughout the case, until we get you the best possible result.